A Cook Islands Trust is an asset protection tool used for U.S. citizens to move their wealth from U.S. accounts to an international country that does not recognize U.S. judgments, court orders, and federal government actions. It's very effective because it comes down to jurisdiction. Once the assets are moved to a trustee company in another country, specifically the Cook Islands, there's nothing or very little a U.S. creditor can do to actually get into the assets. Unlike domestic trusts, a U.S. judge, no matter how frustrated, and a creditor, no matter how aggressive, cannot get an order from a judge to affect the assets. It is expensive to set up, but it's ultimately the best thing you can do to protect your assets. First, let's talk about the core structure of an offshore trust. There's three roles. There's the trust maker, or the settlor. There's the trustee, who has legal title to the assets. And then there's the beneficiary. For an offshore trust in the Cook Islands, you're the trust maker, and you're the settlor. You are the one transferring the assets to the trust and setting up the trust infrastructure. Secondly, there's the trustee. This is a company in the Cook Islands that is licensed and insured and set up to hold legal title to your assets. The trustee company has a fiduciary obligation to hold the assets for you. It's not just some guy on the beach. These are reputable and long-standing companies. Finally, third, there is the trust beneficiary. Almost always that is also you. The trustee company is holding legal title of the assets for your benefit. Day to day, you still have the ability to direct what happens to the assets once they're put into the trust. If you want to invest in Apple stock, you can do so. If you want to hold it in US dollars or some other currency, you can do so. Even if you wanted to hold it in crypto, that's fine. Legally, though, it is the trustee company that has control over the assets. This is by design. If you yourself had legal control, ultimately, over the assets, then a U.S. judge or creditor or government agency could use your control and order you to directly affect the assets, most likely to bring them back to the U.S. where a creditor would be able to get them. Understand that while the trustee company has ultimate legal control based on the trust agreement, day to day, these companies are very customer service oriented, and they're just going to listen to what your directions are. Once you're under legal threat, then any direction from you needs to be verified by the trustee company that it is not given to them under court order or court duress. This is the key concept of the duress provision. The duress provision states that if you are giving a direction to the Cook Islands trustee company under court order, then the trustee company must ignore it. They simply will not listen, and they will ignore the direction given to them because you're being ordered to tell them that thing. This is not just because of the trust agreement, it's actually the foundation of Cook Islands Trust law. There's two other important key concepts with Cook Islands Trust. First is that there is a very short statute of limitations for fraudulent transfers. It is 1 to 2 years, depending on when the transfer was made and when the claim came to be. But more importantly, even if there was a transfer to the Cook Islands Trust that was arguably fraudulent, the creditor must prove the fraudulent transfer beyond a reasonable doubt in the Cook Islands. They have to hire an attorney in the Cook Islands, litigate the case there, and prove to the same standard that is used in U.S. criminal trials. This is a nearly impossible task for a U.S. creditor. In fact, in over 30 years of our practice helping with asset protection, we have never seen a client lose any money due to a claim of a fraudulent transfer in the Cook Islands. The other additional important feature of a Cook Islands Trust is that there are no contingency fees allowed for attorneys. That means that the U.S. creditor must pay an attorney in the Cook Islands to collect against the trust, or even try to, And they can't do that on contingency basis. They have to front the money. Very few creditors are willing to do this. You might wonder whether you even need a Cook Islands trust. The truth is that most people don't. If you have $500,000 or less that you're trying to protect from U.S. creditors, often there are domestic tools that will do the job. But once you are more than that, often you want the best protection possible for what you have, and that's going to be a Cook Islands trust. These tend to be professionals or business owners or anyone that has accumulated enough wealth where they're attracting or they're worried about attracting lawsuits. One final note, a Cook Islands trust is not about hiding your money. Cook Islands trusts need to be reported annually to the IRS. In addition, if you are sued and a judgment is entered against you, you must fully disclose the fact that you have a Cook Islands trust and any transfers into it, especially in the last 4 years. The protection is not from the secrecy or the hiding of the assets. Instead, the protection is from the legal structuring of the Cook Islands Trust, and that's why it works. At the end of the day, the key feature is jurisdiction. There is no domestic option that's going to give you the same type of protection as moving your assets to an offshore trust.